Hello and good morning, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in both Virginia and Texas. It is April the 5th, 2023, and here is all the legal news that is fit to print. We start with a transcript of the hearing yesterday with Donald Trump. Donald Trump was formally arraigned yesterday, having been previously indicted. He was formally arraigned and presented with the first appearance relating to the charges, and we will just read the entire transcript. The clerk, calendar number 1, indictment 71543 of 2023, People of the State of New York versus Donald J. Trump. Appearances, Christopher Conroy. Christopher Conroy for the people, and judge with me are Catherine McCaw, Matthew Colango, Susan Hoffinger, and Becky Marangold. Judge Merchant, good afternoon. Todd Blanchy, good afternoon, Your Honor. Todd Blanche for President Trump. Susan Netchels for President Trump as well. Joseph Tacopina, once again, Joseph Tacopina for President Donald Trump. Judge Merkin, good afternoon. This matter is on for arraignment. Anything we need to address before we conduct the arraignment? Conroy, not for the people. The judge, defense? Blanche, no, Your Honor. The judge, let's arraign Mr. Trump. The clerk, Donald J. Trump, the grand jury of New York County, has filed indictment 71543 of 2023, charging you with the crimes of 34 counts of falsifying business records in the first degree. How do you plead to this indictment? Guilty or not guilty? Donald Trump, not guilty. The judge, people, Conroy, thank you, Judge. First, we are filing with the court and handing to counsel copies of the indictment and statements of facts. Judge, I'm also handing over to counsel a copy of the fingerprint report. I note for the record that the indictment was actually unsealed at 1:30 today and given to counsel for the defendant so they could review that in advance of this appearance. Your Honor, a grand jury sitting here in Manhattan, made up of diligent, thoughtful New Yorkers who did their civic duty, listened to the evidence and carefully considered the charges, has voted indictments against the defendant, Donald J. Trump, charging him with 34 separate felony counts of falsifying business records in the first degree in violation of New York State Penal Law, Section 71510. ADA McCaw is prepared to address discovery, scheduling of motions, and trial date in a moment. With the court's permission, I'd first like to address briefly what the case is about, the defendant's recent public statements, conditions of release, and the conflict matter the people believe the court should be aware of. The judge, please. Conroy, thank you. The defendant Donald J. Trump falsified New York business records in order to conceal an illegal conspiracy to undermine the integrity of the 2016 presidential election and other violations of elections laws. Beginning in about August of 2015, the defendant agreed with others to carry out an unlawful plan to identify and suppress negative information that could have undermined his candidacy for president. As part of the plan, a lawyer employed by the Trump Organization made a covert and illegal $130,000 payment at the defendant's direction. The purpose of the payment was to avoid negative attention to the defendant's campaign by suppressing information about an allegedly sexual encounter between defendant and an adult film actress. After the election, defendant reimbursed the lawyer through a series of disguised monthly payments that hid the true nature of the payoff by causing a series of false business records in the record of the Trump Organization here in Manhattan, and even mischaracterized for tax purposes the true nature of the payment. Defendant falsified these New York business records with intent to defraud, including the intent to commit another crime, and aid and conceal the commission of another crime. The office has long prioritized protecting the integrity of business records maintained here in New York County. When those records are falsified in service of another crime, it is a felony. That is what this defendant did when he falsified business records in order to conceal unlawful efforts to promote his candidacy, and that's why we're here. Next, I'd like to briefly address the defendant's recent public statements threatening our city, our justice system, our courts, and our office. Over the past several weeks and longer, this defendant has made a series of threatening and escalating communications on social media and other public remarks. This includes irresponsible social media posts that target various individuals involved in this matter and even their families. His public statements have, among other things, threatened potential death and destruction. And that is a quote. And World War III, another quote, if these charges were brought and he was indicted. They have directly addressed the grand jury and disparaged witnesses who have purportedly participated in our investigation. Defendant has also directed a series of threatening public statements to the district attorney's office, including posting a picture that depicts Mr. Trump wielding a baseball bat at the head of the district attorney. These comments and posts have led to extensive public safety measures being put in place by a number of law enforcement agencies around the city, including here at the courthouse starting several weeks ago. At this point, I'm going to hand to the court copies of several of the defendant's recent online posts as an example. Sorry, one moment. Handed to counsel in court. Conroy. I'm also handing copies to counsel. These posts are examples of this kind of threatening rhetoric. We have significant concern about potential danger this kind of rhetoric poses to our city, to potential jurors and witnesses, and the judicial process. What these kinds of posts will not do is deter the New York County District Attorney's Office from carrying out its critical public safety mission professionally and even-handedly in connection with every single investigation and prosecution we've handled, including this one. At this point, one way to address the defendant's behavior and rhetoric is appropriately restricted protective order concerning discovery materials, so as lawyers can access information when they need to prepare a defense, while at the same time making sure defendant does not disseminate any information provided as discovery through threatening online posts. ADA McCraw will further address the protective order shortly, and the terms of any protective order the court enters can, of course, be carefully policed through contempt proceedings and other sanctions as necessary. Today, we're seeking only a protective order regarding discovery materials, but we note the defendant's escalating public statements, summing directly at participants in these proceedings and their family members, may also raise concerns about the fair and orderly administration of justice, the risks that pretrial publicity will paint the jury pool and prejudice a fair trial, and individual and public safety concerns. We are considering whether further relief or conditions would be warranted here based on continuing developments, and we'd be prepared to submit briefing if the court requests. I'm going to move now to conditions of release. In addressing the terms or conditions of defendant's release, we note under New York law, these charges are not bail eligible. We further note that defendant surrendered voluntarily for his processing arraignment today. We're asking the court to give defendant Parker warnings before he leaves the courtroom today. Should the defendant decide got to return to the court from out of state, these warnings would help mitigate potential issues around any extradition proceedings. Finally, if circumstances change and we believe modifications of these conditions are required, we will advise the court. Last on my list, we'd like to bring to your attention a potential conflict Mr. Tacopina may have, given our understanding that he previously had privileged communications with Stormy Daniels, who we expect to be a witness in this case. We believe it appropriate for you to conduct an inquiry at an appropriate time of both Mr. Tacopino and the defendant about potential conflict issues relating to prior dealings with Ms. Daniels. We received a copy of a letter from Ms. Daniels' current lawyer, which was sent to Mr. Tacopino on this issue yesterday, Monday, April 3rd. We can file a copy with the court and serve it on counsel within the next day or so, if that would assist the court in considering this issue. At this point, if it's okay, I'm going to turn to Ms. McCaw to talk about other discovery and other issues. The judge, of course. Counsel, Blanche. Your Honor, thank you. I didn't realize we were going to give opening statements today. Lol. I'd appreciate the opportunity to respond. Your Honor, the people just talked for 10 minutes or so. It sounds like the strength of their case. They did that. There is no trial. We've not seen discovery. It's actually consistent with what the witnesses have been doing. They've been calling over the past several months. Indeed, their main witness, Michael Cohen, walks out of his office and stands on the courthouse steps every time he meets with prosecutors, every time he testifies in the grand jury, announces exactly what he's doing and why he's doing it. It's true that Mr. Trump has responded and responded forcefully. It's true that as part of that response, he's absolutely frustrated. It's true that President Trump has responded forcefully. It's true that as part of that response, he's absolutely frustrated, upset, and believes there's a grand injustice happening with him being in court today. That being said, Your Honor, for the people to stand before you and give their version of this indictment, it's actually an exasperating problem. So the complaint was that deep breaths. So the complaint from the people is that the President Trump is talking too much about the case, talking too much about the investigation. The judge, I'm not sure that is what they were saying. They're complaining about the rhetoric and the charged nature of the language being used. Conroy, that's correct, Your Honor. Blanche, if that's the case, the president has not only a free speech right to talk about his view of what's happening in the district attorney in this case, and also it's important to step back, Your Honor, to realize this case has been investigated for 3.5 years. Your Honor, one of the main investigators with this office left the office, wrote a book about this investigation, published a book, and has talked about the book publicly. Thereafter, as I said, the people's main witness has talked repeatedly, not only about the courthouse steps, but on every news show, and print media. He has written 2 books. He has a podcast, all talking about the case. The president is running for re-election to be the president of the United States. I mean, imagine anyone in this courtroom that was in that position, an investigation that lasted over 3 years, with over 3 years with leaks galore. The people were right. We received a copy of the indictment about 40 minutes ago. The media received a lot of these hints about the indictment last Thursday night, and a copy of the indictment last night, apparently. That is a grave injustice. The people didn't address that. They have not addressed the fact there's literally a violation of law that happened at some point in the past 5 days with illegal leaking of charges against President Trump. What they did address is their frustration when President Trump sees that, when he sees a legal leak describing charges that he knows nothing about. When we speak with the assigned ADAs, they correctly tell us they can't share anything with us because it's sealed. And then he's frustrated and comments publicly about that. You can, I think, discuss words that are used, but every one of these posts are not threats, they're not harassment. And the rhetoric maybe the people don't like, sure, but I think it's patently unfair for someone who's running for president of the United States, for someone who sat by and watched for 3.5 years an investigation go on about a $130,000 payment before the last election, by the way, to be frustrated and speak publicly. He has rights. He's allowed to speak publicly. The judge. Okay, certainly, of course, Mr. Trump does have rights. And I don't believe that people are asking the court to impose any kind of gag order. I certainly didn't hear that. Blanche, agreed. The judge. Certainly, the court would not impose a gag order at this time, even if it were requested. Such restraints are the most serious and least intolerable in First Amendment rights. That does apply doubly to Mr. Trump because he's a candidate for president of the United States. So those First Amendment rights are critically important, obviously. I don't share your view that certain language and certain rhetoric is just by frustration. So although I'm not going to issue a gag order and not something close to a gag order, I would encourage counsel on both sides, the people, to please speak to your witnesses, defense counsel, speak to your client and anyone else you need to, and remind them to please refrain from making statements that are likely to incite violence or civil unrest. Please refrain from making comments or engaging in conduct that has the potential to incite violence, create civil unrest, or jeopardize the safety or well-being of individuals. Also, please do not engage in words or conduct which jeopardizes the rule of law, particularly as it applies to these proceedings in this courtroom. That is a request that I'm making. I'm not making an order. But now that I've made the request, if I were to be handled something like this again in the future, I'd have to take a closer look at it. So I ask you to please discuss with your client and the people, also discuss with your witnesses. Conroy, Judge, I just note for the record that we've done so and will continue to do so, and we'll do everything we can to camp down on any witness comments in public, but there's only so much we can do. The judge, thank you. McCall, thank you, Your Honor. I'd like to address 3 matters before the court today. The first is the protective order the people are in the process of working out with defense counsel. The second issue is discovery, and the third issue is scheduling. So to begin with respect to a protective order, the people believe with respect to a protective order, the people believe, especially in light of defendants' public comments, The protective order is vital to ensure the sanctity of proceedings, as well as the sanctity of discovery materials. We are in the process of working out a consent protective order with defense counsel. We have had a number of very productive conversations. I believe they're very close to agreement in finalizing this language. I expect when we do reach an agreement, we should be able to submit the language to the court within the next few days, hopefully. One thing I'd like to highlight, however, is the proposed order, should the court enter it, would have terms that would be binding not solely on defense counsel, but also on defendant himself. And should defendant have the failure to abide by the terms, it could have the effect of being contempt of court. So I just want to highlight three terms. These are terms in which the defense and people have reached a broad agreement. The first is defendant may not use any of the materials the people produce for any purpose other than to prepare for its defense of the case. The second is defendant will be permitted to review certain sensitive materials only in his attorney's office and may not make copies of the documents, portions of the documents, notes he took of the documents, etc. with him after he leaves the attorney's office. And third, and perhaps most importantly, defendant may not provide the materials he receives through discovery process to any third party, including the press, and may not post them to social media. And I'll note again for the record that should the defendant, after the court enters the order, violate any of the materials of the protective orders, he could be in contempt. The judge. Before you move on to discovery, I'll turn to defense counsel. Are you working on protective order? Naturals. Yes, Your Honor, thank you. We are working on it together. We hope to reach an agreement. We just received another copy of it. I will note the people in their statement of facts. Here have laid out what I assume contend the grand jury evidence and testimony showed. So I'm concerned and we need to go back and discuss this. It seems fundamentally incorrect for the people to be able to put out a public statement of what they believe the facts are, and for the defense and someone who's defending his career, his reputation, everything that he's built his entire life on, to not be able to respond in the same manner. So we need to look at what's in here and further discussions. We hope to do that promptly. The judge. I hope you're able to come to a meeting of the minds of the protective order, so all I have to do is sign it. Tacopina. One thing of the protective order. I know the DA said the review by defendant would have to be in the attorney's office. That will not happen. I thought it was in an attorney's presence. We most likely meet at the office of President Trump. The judge. All right, since you're still negotiating, I will not weigh in at this time. If you reach an impasse and need my help in resolving anything, let me know and I'll try to help out. Now to the issue of discovery. McCall. Yes, Your Honor. Once a protective order is in place, the people expect will be able to begin making rolling productions of discovery. We expect the productions of discovery will take place, broadly speaking, in three stages. The first stage of materials will be materials that consist of grand jury minutes and exhibits, as well as notices of witness statements for those witnesses who tend to testify at the grand jury. We would expect to be able to provide those materials to the defense within a week, assuming its appropriate protective order in place. The second stage of discovery will consist of a subpoena compliance, other witness materials, as well as some police documents and other odds and ends. We believe this group of discovery materials will be the bulk of the people's additional discovery materials, and we expect we'll be able to produce those materials within 65 allocated days by statute for voluminous discovery materials. There will probably be a third stage of discovery that may consist of materials such as internal documents from the district attorney, such as email messages. We don't have any sort of visibility as to how long production of those materials would take. I should note for the record, we believe the materials that we produce in the first and second stages, particularly the grand jury materials in the first stage, will be the most important materials that people will provide. We'd also like to note for the record that we understand there's intense public interest in moving this case along as expeditiously as possible. The people intend to request a trial date in January of 2024. So we'd like to produce these materials for defense as quickly as possible to allow defense ample time to prepare for trial in January 2024. The judge. All right, would you like to be heard? Blanche, Your Honor, I'll not repeat what I said before. This has been a long investigation. We don't have any discovery yet. The people, and certainly the president, wants this behind him. But to sit here and say January of 2024 is good with us, when we've not seen a piece of paper yet, I think is patently unfair for us, given everything we know about the case from the media and certain witnesses talking and what we know. But certainly, we think that's a bit aggressive. We think later in the spring next year might be more realistic, and more realistic plan at this point. But I'm speculating a bit because we've not seen anything yet. The judge. All right, I understand what you're saying. I think that's reasonable. You've not received discovery. It's difficult for you to anticipate if you'll be ready for trial in January 2024. The message I'd like to deliver is we'd like to move ahead as expeditiously as possible without undue delay. Of course, you're entitled to discovery. You're entitled to review discovery and make determinations there. Okay. McCall, thank you, Your Honor. The next topic we'd like to discuss is the schedule going forward. I believe the next step would be to set an appropriate motion schedule. The people have dates they'd be willing to propose, but I understand as well you might want to hear from the defense. The judge, I would. So ordinarily you get 45 days. I know this is a much more complex case. As you've seen in a couple recent cases I preside over, I extended the motion schedule. What did you have in mind? Blanche. Thank you, Your Honor. We appreciate the consideration. I'd like to answer that in two parts if I could. One, we strongly believe there will be substantive motions addressing the substantive factors of the indictment that could be dispositive. Those motions certainly may, after we review discovery, because we rely in part on the materials produced from the people. That being said, we do believe that to move the case along expeditiously, there may be other motions that do not need to wait for substantive motions several months from now after conclusion of discovery. And so, for example, the potential bill of particulars. We just got a statement of facts today. That might be also something we're going to need before we go through discovery. Just by way of aside, by the way, a bill of particulars is basically asking for a more specific pleading. So they're speculating about something they might need in the future, which they're going to need, but that's an aside. So what we would I'm a professional. All right. So what we'd ask, Your Honor, is we have an opportunity to study the indictment beyond the half hour or so we've had so far. Continue to think about potential motions and potential file motions in two parts. So motions, and we'll communicate with the people and with the court as we land on specifics, of which the motions and timing, but some of the motions potentially dismissing the indictment after we've had a chance to review discovery. So I don't know if it's worth setting a date now, but if the court would like to, we could say at least 6 weeks after discovery has been concluded. And for other potential motions we'd have to reach out to the court about, we'd have to ask a month to file those motions or at least inform the court of what motions we intend to file. The judge. So people, when do you expect to complete discovery? When call. As I indicated, Your Honor, we believe that the vast majority of materials will be turned over to the defense within 65 days of arraignment. There might be some additional straggler materials, especially the internal email review for the district attorney's office. That said, however, I don't believe the materials that would come out post 65 days would be particularly meaningful. Obviously, the defense is entitled to see every single email discovery in this case, but those email messages tend not to be the most significant materials. I'd also like to say the extent to the defense does intend to file a set of motions immediately, and once additional time after discovery is complete to file a second set. We ask a motion schedule be set at this date for a first set of motions rather than waiting for a later date to set the motion schedule. The judge. All right. So the 65 days would bring us out almost to mid-June at this point. I'm not in favor of splitting this up into two set of motions. I'll set one motion schedule, which I believe will be reasonable. If you disagree, let me know. I think 4 months would be more than sufficient for you to be able to address your motions. So that brings us out to August 8th. And so by August 8th or before, please file any and all motions. Blanche. Thank you, Your Honor. Just one caveat. To the extent we believe we need to file a motion in advance of that, we'll alert the people in the court, and obviously Your Honor can guide us. But the dates you just described, assuming the schedule stays as the people suggested, works for us. Thank you, Alan Parker, for 50 gift memberships. That's very, very nice. Thank you. I feel validated this morning. You've warmed my heart. Thank you. It's nice. Feel loved. The judge. All right. So that brings the people to, let me check my math here. I believe that brings the people's response to around September 5th. Your Honor, if we're having 6 weeks, we appreciate 6 weeks as well. That brings us to September 19th if that's possible. I'm not giving them 6 weeks. I'm giving them basically 4 months from today to complete all their motions. That's what brings us to about August 8th. McCall. So if we could get about 6 weeks from the date of filing their motions in light of the amount of time they'll have to prepare the motions, we'd request a day of September 19th. Okay. People's response off calendar. Defense motions be filed off calendar. People's response is to filed off calendar also by September 19th. I believe that covers the three issues you wish to address. McCall, that's correct, Your Honor. The judge, Mr. Tacopina, Mr. Trump. The people have asked me to discuss with you the possibility that Mr. Tacopina might be conflicted out of this case. Tacopina, can I address some things said? The judge, sorry. Tacopina, can I address some things that were mentioned by the district attorney regarding that? The judge, sure, go ahead. Tacopina, just to give some additional context and whatever the court deems necessary, we can have whatever the court deems necessary. To be clear, we received last night for the first time a letter from Clark Brewster, an attorney apparently representing Stormy Daniels, that was lauded with factual inaccuracies. First and foremost, I never met Stormy Daniels. I never spoke to Stormy Daniels, and I never reviewed any documents of Stormy Daniels. I know we're not doing a full-blown hearing here, but I want to give the court some context. She called my office, like many people do, and tried to hire me or ask about hiring me. She spoke to an associate and paralegal, gave some facts, sent over a document, went no further than that. We refused the case. I did not offer her representation, didn't speak to her, didn't meet with her, and it's as simple as that. Of course, there's a rule governing that in New York, the rule of ethics, Rule 1.18 regarding duties to prospective clients, and most importantly, what happened here is I have been in possession of information that's significantly harmful to the person in matter. I know we're not doing a full-blown hearing, I just want to put some things on the record. Your Honor, first of all, that does not exist. Everything she sent to us wound up in her book. So there's not obviously any privilege, and anything that existed was waived. But moreover, I have documents supporting this, that Miss Daniels or Miss Clifford, whatever her name is, signed a waiver, an attorney-client waiver, when she turned over all attorney-client communications to the federal prosecutors in the Southern District, waiving any attorney-client privilege to begin with. She testified in open court about her attempt to secure representation prior to retaining Mr. Avenatti. Mr. Avenatti does make an appearance. I knew it wouldn't take long. She wrote a book regarding everything that had to do with potential representation and the document in hand. And unless there was ever a point in which the court deemed there was a conflict, which I submit based on this there's not, we can submit our writing, our position from Michael Ross, who's one of the most important ethical lawyers in the country, or in the city. Most importantly, if we got to that point, we're not to that point, the remedy would be I don't participate in her examination. There are 3 different law firms here. It's as simple as that. So I just want to give the court our position as to the factual assessment. The judge. People, what's your basis for believing there might be a conflict? Conroy. It's I'm dying. The judge. What is your basis for believing there might be a conflict? Conroy. Judge. It is a combination of the letter we received, which I compiled with the court in short order. And also, I believe there have been comments made on various TV networks, perhaps even by Mr. Tacopina, and there are some privileged conversations between them. If the court, obviously, if there will be submissions, we're happy to engage in that process. Again, we want to alert the court to the potential issue. And I think there's a real potential issue that needs to be explored. Okay, so if that's your position, Mr. Tacopina refutes that. So what I'd ask, if there comes a point where you'd like to submit a motion on this, I'll welcome it. In the meantime, I do believe an obligation to address this to both Mr. Tacopina and Mr. Trump with regard to this. So Mr. Tacopina, Mr. Trump, as you know, you have an absolute right to conflict-free representation. The people have alleged there's potential that Mr. Tacopina has conflict. And the basis for this belief is that he may have represented a former client who's a witness in this case. At this point, I'm not making any findings of fact. I'm not deciding who's telling the truth or who is not telling the truth. I simply want to inform you that because it is an important right. I also want to first, do you understand that right, Mr. Trump? Trump, yes. And the judge. And therefore, the people are not filing a motion at this time, but you're certainly welcome if you wish between now and then to consult with other counsel on this issue by them and see how you feel about that when it's over, okay? Trump, okay, thank you. The judge, all right, I believe the only other issue is the Parker issue. Conroy, correct, judge. The judge. So, Mr. Trump, the people asked me to give you what are called Parker warnings. I want you to know I would have given these to you whether they asked for them or not. This is something I do with every individual who appears before me in the courtroom. Please bear with me as I do this. You have the right to be present at every stage of the proceedings in your case, at every proceeding involved in this case, and it's obviously a very, very important right because it allows you to assist your attorneys in defense of you. It allows them to consult with you in your defense of you. I think it's definitely advantageous to have the jurors, if there is a jury, to see you present. So, for all those reasons, I'm sure you can appreciate the right to be present at your trial and your proceedings is important. I'm required by law to inform you that there are ways you can waive these rights to be present at proceedings. Specifically, I like to refer to two specific areas. You can waive your right to be present if you voluntarily absent yourself from proceedings. So, if it's determined at some point down the road you're not present at some stage because you chose not to be present, I do have the authority. I do have the right to find you voluntarily waived your right to be present and continue proceedings in your absence. Do you understand that? Trump, yes. The judge. A second way you can lose your right or waive your right is become disruptive, and I do not have any reason to believe that will happen. But if you become disruptive to such a degree it affects my ability to preside over the case, and my ability to ensure the case is treated in a way it needs to be treated for both sides, I do have authority to remove you from the courtroom and continue in your absence. Do you understand that? Trump, I do. The judge, all right, if either one of those situations were to happen and the case were to go to trial, we go to trial without you. If there were a verdict and the verdict were to be guilty, we'd be able to take that verdict without you. And if there were time for sentencing, we'd be able to post sentence without you. Do you understand that? Trump, yes. The judge, I think we need to set an adjourned date. Having read Mr. Trump's Parker warnings, Mr. Trump will be released on his own recognizance. So we picked September the 19th for the people's response? McCaw, yes, Your Honor. The judge, all right, let's set this down for December 4th for court decisions on motions. That will be here in person. So again, defense motions filed off calendar, people's response filed off calendar, but we need to be back here in person on December 4th for court decisions on motions. If for some reason I'm unable to have my decisions ready, or not all the decisions are ready, I'll certainly let you know. Blanche, judge, very, very briefly on the adjourned date. I'm just stating the obvious, that having President Trump in the courtroom today is extraordinarily burdensome and expensive for the city, and with security issues that have taken place allow us to be here today. I do not know, Your Honor, we've decided this today, but we may ask President Trump in his presence to be waived just for that date. We will speak with the President and others in advance if necessary to request that of court. The judge, you probably don't know now because you're not making application. What would be the reason for asking to waive his appearance? Blanche, just the simple fact of the incredible expense and effort and security issues that present themselves with the President being in and out court. All of Lower Manhattan was shut down today. Okay, this is off the transcript. But my response as a judge at this point would be like, that is distinctly your problem. He has the right to be present, so deal. Anyways, going back to the transcript. To the extent it is a conference or a decision that is announced, not anything that requires us to simultaneously consult with President Trump, we may ask his president to be waived. The judge, would you like to be heard? Judge, I just say, as I'm sure you know, our general preference is for defendants to be in the court on the court date. We also recognize, as the counsel explained, the immense burdens placed on the court system. So we defer to Your Honor's decision. He just told you he has the right to be present. The judge. Well, there's no question it was a huge undertaking for everyone involved, from Mr. Trump, the prosecution, the city courts, there's no question about that. At the same time, today is April 4th, and we're looking at our first adjournment in December. That's quite a ways out. You know, if a reason were to come up that your client was unable to appear on that date, something unanticipated, you could certainly run that by me. But in the same way I expect all other defendants to appear in court, even high-profile defendants, I agree, we wish we could avoid all these logistical challenges. I think in the interest of transparency and assuring rule of law even-handedly, at this time I'm going to deny your application. Thanks. Thanks, Judge. I appreciate that. Go eat it. If you have another one, you can make it. Blanche, thank you. To be clear, I was not suggesting President Trump does not want to be here. I'm suggesting, having lived past several hours as Your Honor as well, the expense and cost of the city for the arraignment. That was the reason to bring it up. I appreciate the court's guide. To the extent we need to, we'll revisit. The judge, what you said is true and I agree. Thank you all very much. And thus, that will bring us to the end of the transcript. So, yeah, that's... So, now the December 4th date makes more sense. The prosecution gets 65 days to turn over discovery by law. And so they're like, okay, 65 days. So that's 2 months. And the judge is like, okay, well, I'll give defense another 2 months to file any motions because it could be complicated, which, you know, fair. And then the people need a chance to respond to that, so they get some time to respond. And then the judge, of course, needs some time to analyze the issues and issue a decision, which brings you to December. So that sounds a lot more reasonable now. Okay. And the judge was also advising Trump that of the potential issue of the conflict. Fair. There's an issue raised. Make sure that the client's aware of it. Fair. Fine. Reading these mandatory things. And then the people over here, we'd like to ask him to waive his appearance. And as a judge, I'm like, I just told him 5 seconds ago that he has the right to be present. And now they're like, we want to waive it because it's inconvenient for us. That sounds distinctly like a you problem. So, yeah. Okay. So that was entertaining. All right. And I apologize that I have this little cough this morning. I apologize because I want to be a professional and I'm not my professional best. And I also appreciate, by the way, all of you guys who are here as we work on the format. So just little behind the scenes stuff. I said this sort of in the chat beforehand. I anticipate that it'll take about 2 weeks minimum to figure out what the format is for what this morning stream is going to do. So, in terms of things, I'm not sure that reading that entire indictment just now, was necessarily a good use of what this is supposed to be. I'm not sure that's what it's supposed to be because it took so long. I'm not sure it's really doing what it's supposed to do, but I'd like your feedback because maybe I'm wrong. Maybe you really liked that. Maybe you really liked a full reading of the transcript. And maybe you'd like more interjections or more analysis in between. I read it mostly without interjection because I wanted to just kind of read it as it was. But maybe you'd like more interjection. Or maybe you thought it was just too long and you wanted to be quicker hits and stuff. I'll take your feedback into consideration as I'm considering what I kind of want this to be. So, and then, once we sort of have a better idea about what the format is going to be, then I might release this as a podcast within YouTube. Right now, it is just listed as a regular playlist. So I just created a playlist for this yesterday, for yesterday's today. So our sort of pilot episodes, I guess we're calling them collectively, our pilot episodes of this thing will be one playlist, and then maybe I'll create a second or a new playlist once we create a regular thing. So, yeah. All right. So that's enough behind the scenes for now. Let's do another story. Also, by the way, I would appreciate your suggestions on the title of the stream. The legal news roundup isn't bad. Roundup is nice because it does have that sort of Western element. So it fits in nice with the channel, sort of as a nod to the channel. So that's nice. I'm looking for something that will kind of do what it says on the label because I don't want to be too clever about it because I want someone who has zero familiarity with the channel to see it and know exactly what they're getting. And I want it to be interesting. So legal news roundup isn't bad to accomplish those purposes because it kind of does exactly what it says on the label. And also the word roundup, it has a little bit of a Western element. So it also has a nice tie-in with the channel. That being said, however, I'm open to other suggestions. So if you have better suggestions for the title of this thing, let me know. All right. For our next article, we cover a article from National Review that is critical of the indictment because National Review feels it fails as an indictment. National Review writes, it's always possible to be surprised. The indictment brought by Manhattan's elected Democratic district attorney against Donald Trump is even worse than I imagined. The indictment fails to state a crime, not once but 34 times. The 34 counts are arrived at what's taking a single course of conduct, absurdly slicing it into parts, each one of charges a separate felony count, carrying its own 4-year terms. The reimbursement to Michael Cohen in monthly installments during 2017 for $130,000 paid to the porn star Stormy Daniels right after the 2016 election for silence about the affair. That is in reality a single transaction, Trump paying back Cohen. Yet because he paid in installments and each installment includes an invoice from Cohen, a bookkeeping entry by a Trump organization, and a payment to Cohen by check, Bragg not only charges each monthly installment separately, he subdivides the installments into installments as if the invoice, book entry, and check were independent criminal events. Viola, one criminal transaction becomes 34 felonies. As I observed a couple of days ago, this is exactly the sort of abusive behavior that rogue prosecutors engage in, and thus the Justice Department admonishes federal prosecutors to avoid, which is true. Federal prosecutors don't do this. Federal prosecutors actually have standards. Here from the Manhattan DA's attorney, from the legendary lawman Robert Galthrew, led for 34 years no less, we now find an egregious example of this low tactic as one is fine. In a real prosecutor's office, the district attorney is the adult who makes sure inexperienced young subordinates don't abuse their power. In the Manhattan DA's office, Bragg is the exemplar of abuse. The worst due process abuse of the indictment, however, is that it's not an indictment. The Constitution's Fifth Amendment guarantees that Americans may not be accused of a serious crime, especially a felony, absent indictment by a grand jury. The indictment has two purposes. First, it must put the defendant on notice of exactly what crime is charged so he may prepare for defense. Second, the indictment sets parameters for defendants' closely related right to double jeopardy protection, also set forth in the Fifth Amendment. That is, by stating the crime charged, the indictment enables the defendant to claim double jeopardy violations if the prosecutor's attempts to try him twice on the second event. Here, the indictment fails to say exactly what the crime is. Bragg says he's charging Trump with felony falsification of records under 17510 of the Penal Code. To establish the offense, Bragg must prove beyond a reasonable doubt that Trump caused a false entry to be made in a business record, and he did with intent to defraud, that specifically including trying to commit another crime or aid in the concealment of another crime. Nowhere in the indictment does the grand jury specify what other crime Trump fraudulently endeavored to commit or conceal by falsifying the records. This is a problem. It's also not clear in the statement of facts, incidentally, what the other crime is. So, this is why I said in the other video there might need to be a statement of particulars, because this seems like a problem. It doesn't provide enough notice of what exactly they think you did. It allows them to fill in the blanks in a way that's too problematic. So, yeah. The indictment fails to alert Trump of what law he violated, much less how he violated. If any prosecutor were ever daft enough in the future to accuse Trump of falsifying records to conceal, say, a federal campaign finance crime, Bragg's indictment would be useless for double jeopardy purposes because it doesn't specify what criminal jeopardy Trump is in. We needn't speculate about why he's being so coy. He doesn't have another crime. At his press conference, he blathered on about federal campaign finance law, but he lacks jurisdiction to enforce that. There are problems using the federal crime as a predicate. He further mumbled something about state election laws, but those, as you might imagine, apply to election for state office, not presidency. State election law appears to be irrelevant. In this particular context, the federal election law appears to preempt the field. I don't think he can use the state crimes as a predicate. So it's federal or nothing, and I don't think he can do federal because it's not state. So, yeah. And the DA's streams of consciousness about Trump's intent to defraud tax authorities is belied by the fact he doesn't accuse him of evading taxes, despite already prosecuting Trump organization for tax evasion. Yeah. So this is a problem. It is not clear what the predicate crime is from the indictment. It's certainly not clear from the indictment. It's not even clear from the statement of facts exactly what it is. There's allusions to it, but it's not clear. So there is a problem with the presentation of the charges, among other problems. Moreover, the document that Bragg has determined to label a statement of facts, filed in court with tandem of the no notice indictment, is itself a work of fiction. He alleged Trump falsified records to conceal damaging information from the voting public during the 2016 election, but every one of the 34 acts happened after the 2016 election. From February towards December 2017. That too. That's a problem. There are many. These points are not invalid, friends. These points are not invalid. Right. There's counter arguments to be had, but there are issues. Like, how do you conceal the 2016 election in 2017? So there are some issues. All right. Next story. From Newsweek, asking the questions if the statute of limitations has run out. Questions that I have asked as well. This article written by a former assistant district attorney in New York City. That's County of New York, which is the same place. So this guy might know something about the issue. So let's see what he has to say about the statute of limitations issue. New York's criminal procedure law establishes the statute of limitations as 2 years for misdemeanors and 5 years for felonies. While it's expected all the charges are nonviolent felonies or misdemeanors, meaning that he'd be barred for any crime that took place before March of 2018. Assuming Trump is only under investigation for payments to Stormy Daniels, which took place in October 2016 or 2017, as the case may be, he can't be prosecuted because there's a statute of limitations problem. New York does identify a couple ways to stop the statute of limitations clock. If defendant were continuously outside the state or defendant's whereabouts unknown, then the clock is toiled. While if Trump's whereabouts were pretty much continuously known since the alleged payments were made, he was living in DC and Florida, but not continuously outside of New York because he spent time in New York, at least through 2019. So he wasn't continuously out of New York in the relevant time period. So we can easily argue that he was not continuously outside of New York. Okay. The New York's highest court has clarified that means it's difficult to apprehend the criminal offender. But of course, in this particular context, that doesn't make sense because, we know who he is. He's not a scofflaw. He's the most tracked person in the world. So it's not hard to find him. So whether or not Trump can be prosecuted comes down to a calculation of days. Trump's team will point to his continued residency in New York during his presidency. He was a legal resident of New York during the relevant time period, his legal place of domiciled. And he still spent considerable periods of time in New York. Yeah. The best case scenario is that the clock stopped since Trump assumed office in 2017. But there's a real statute of limitation problems because he was still a legal resident of New York through 2019. He was physically present in New York. And so there's a statute of limitations problem. It appears that the governor of New York tried to give more time by executive order. like by saying, okay, you can have more time, but I'm not sure how an executive order can amend a statute of limitations. So I have questions. So yeah, the statute of limitations problem is real because all this happened more than 5 years ago. He wasn't continuously out of the state. His presence was very, very well known. Like, where is he? It's easy to figure out. And yeah, so there's a statute of limitations problem, and I'm not sure the governor's executive order can do what it's trying to do. So there's statute of limitation problems, so it's going to be an issue. So that'll be an interesting fight. Another story about Trump. It's Trump morning today. Executive Law 29A, that's how an executive order can amend a statute. Okay, let me give it a quick look. Why not? Man, hey, if I can get answers to my questions, let's see. Let's see what it says. Suspension of other laws. Subject to state constitution, federal statutes and regulations, government may by executive order temporarily suspend specific provisions of any state, local law, ordinance, or orders, regulations part of an emergency. I don't know if that works in this context. Yeah, I don't know if that works in this context. I have questions because it's criminal in its nature. Because it's criminal in its nature and increases criminal exposure. I don't know about that one. It's not a bad idea, so I don't fault you for the idea, but I'm not sure about that one. Yeah. Because it's criminal in its nature. And the nature of the suspension in this particular case is a nature that would potentially increase someone's criminal exposure. And I'm not sure about that one. So I'm going to stick with I have questions. Would it be appropriate for the state Supreme Court to make that decision? Well, in this case, it would be the Court of Appeals, not the state Supreme Court, but yes. Eventually, I'm sure. To the extent it's not a federal problem. I'm not sure whether or not that presents a federal issue or not. It's a thing, though. There are problems. There are problems. There are questions. There are questions that need to be answered. Questions that don't have clear answer right now. All right. Yeah. Let's see. Next article. From New York's Intelligencer. The first case against Trump is this: the first ever criminal prosecution of a former president follows numerous missed opportunities. Depending on how you count, the country is about to enter either the 7th or 8th year of contemplating Donald Trump's imprisonment. Yeah. If you mark the start of the public appointment of Robert Mueller to handle the Trump investigation, then we're coming into year 7. But you could reasonably make the case that really entering year 8, considering contemporaneous questions about his conduct during 2016. The prospective prosecution is being described among liberal observers as the least significant and weakest one facing Trump, the hardest to prove among all the legal cases Trump faced, one with manifold legal and evidentiary problems, There are concerns, of course, that the indictment might even boost Trump's reelection prospects. Yeah. In New York, a defendant can be convicted of falsifying business records at the misdemeanor level if he makes or causes a false entry in a business record of an enterprise and does with intent to defraud. The charge can be escalated to a low-level felony with a 4-year maximum term if the defendant intended to commit another crime or aid in concealment of the crime. Trump would likely posit defenses to every element of the offense, arguing he didn't intend to defraud anyone, that the entities within the Trump organization are not materially false. He isn't trying to commit or conceal another crime since the payment by itself didn't actually run afoul of law. Even assuming that another federal criminal offense would qualify as another crime, which itself is unclear for reasons we've discussed, using the federal crime as predicate is legally unclear. The New York Times has described the prospective case as one that hinges on untested and therefore risky legal theory involving a complex interplay of laws, all amounting to a low-level felony. It's not just the conservatives who have expressed some doubts on this. There's definitely been issues in the left-leaning press. They're also like, we have questions. Yeah, so that's basically all I have to say about that article, to be honest. Just more questions, more doubts. Let's do another story. Let's do something different. I'm tired of talking about Trump right now. Okay, let's talk about something else. All right. All right. Sig Sauer is facing another lawsuit involving its P320 pistol. This is alleging manufacturing defects in the pistol itself, that the pistol itself is defective. This is not the first lawsuit against Sig Sauer or this pistol. This does not have a problem with the Lawful Protection of Commerce Act, federal law, because this is a product's defect that is based on the nature of the pistol itself. So Sig Sauer is being sued for product liability because they manufacture an inherently defective pistol, or so the allegation is. Okay. So Sig Sauer is facing a new lawsuit by 20 people, including federal agents, police, and civilians, who say they were injured when the company's model P320 pistols fired without a trigger pull. The lawsuit is the latest in a series of complaints filed against the company, each claiming this particular pistol has a design flaw that leads to unintentional discharge of the firearm, occasionally while holstered. So this is not the first thing that's been done against Sig in this particular pistol. So there's some question here that there might be some sort of problem with the way it's manufactured. We are calling on Sig to do what it should have done a long time ago, recall the P320 and redesign the gun with type of safeties used by its competitors. We fear that more and more Americans, law enforcement, and responsible gun owners alike will continue to fall victim to this weapon. The attorney says after every lawsuit the firm files, more and more users have contacted regarding injury from unintended discharges. Every complaint adds to the avalanche of evidence regarding dangers of the product, in which everyone who's experienced a P320 accidental discharge to contact us immediately. In a written statement, Sig Sauer responded to the lawsuit by reiterating its stance that the P320 is designed to fire when the triggers pull. It says it includes internal safeties that prevent the firearm from discharge without trigger pull. The New Hampshire complaint is claiming of trigger pull of the P320 necessitates an external manual safety to protect against discharge. However, the trigger pull force of the P320 is consistent with industry practice, and Sig offers P320s with a manual safety, providing its companies the opportunity to choose that if they want it. Some customers, including many law enforcement agencies, believe inclusion of a manual safety is detrimental to safety and reliable use. Given the customer choice and opportunity to exercise philosophy of use is good. The plaintiffs include U.S. Army veteran Cody Higgs, Milwaukee police officer, Virginia State trooper. In September, the federal judge ruled Sig Sauer's favor in product liability suit brought by Hillsborough man. The judge said that they failed to prove Sig Sauer knew its advertisement safety without compromise was false. So there are some issues here potentially with this firearm. I don't have enough familiarity with the SIG brand in general or the P320 to offer a particular comment, but I will take note here that this is not the first lawsuit that has been filed against this, and there seems to be some sort of credible allegations that there might be some sort of defect here, that the gun might fire other than with an intentional trigger pull. If it fires in the holster in particular, if it can be operated that way, there might be a problem. So, there could be some sort of issue here, so I bring it to your attention. So, I think there might be an issue here. All right. Glock striker's not fully clocked until the trigger's pulled. The P320 has a pre-clocked striker. Yeah, that's not great. Yeah. So, yeah, could be a problem. All right. All right, new story. Internet Archives has lost a lawsuit over ebook copyright infringement. The Internet Archives is a very popular website that offers old websites and old things, but they also offer ebooks, and they have a problem. A federal judge sided in favor of 4 leading publishers in the U.S. who sued Internet Archives for scanning and lending out numerous digital copies of a copyright book for free during early days of COVID. Various groups sued the non-for-profit after the group created a national emergency library, a temporary book collection created from thousands of ebooks. The Internet Archive says the emergency library was help people who lost access to physical libraries. For the National Emergency Library, Internet Archive was lending out multiple copies of a digital book at once. Uh-oh. And 4 publishers sued over the 127 books in the collection. The district judge agreed with the plaintiffs, saying that the Internet Archive was making derivative works by printing the books and distributing them. The Internet Archive is a nonprofit that's built a digital library of websites, books, audio recordings, videos, images, and other research material. The nonprofit has been digitizing books since 2005. The Internet Archive, which creates ebooks by scanning print versions, includes 3.6 million copyrighted books. Of those millions, they offer free downloadable books that were published before 1927, no copyright issue there. More modern books can only be borrowed from their open library, where users have to make a free account in order to borrow the book. If it were one for one, they'd be in a different position. But it's not, so they have a problem. Libraries have a right to lend physical books to users because of the first sale doctrine. Under Internet Archive's regular models, it does not allow users to make mass download a book. Instead, it functions through controlled digital lending, which allows entities that own the physical book to scan the book and circulate it in place of the physical one. But controlled digital lending also requires libraries only lend the number of copies it owns. The Internet Archive counts its own physical copy of a book, and up to one book copied, owned by its library partners, to determine the number of books. But it didn't use this practice during the pandemic. That's the problem. That's where you go into oopsies territory, right? So they lent out more books than they had. So first sale doesn't apply. Now they're just making copies. They claimed fair use, but that's a bunch of bullshit. The judge ruled that the ebooks did not adhere to the standards when rolling out the library, but there was nothing transformative about the books. The defense rests on the notion that lawfully requiring copyright book entails the recipient make authorized copy and distribute it, but no legal case supports it. And yeah, so that's Internet Archives did it bad. They did it bad. They let out more copies that they had. If they'd only lent out the copy they had, they'd be in a different argument. But they didn't. They hey, just download as many copies as you want. Yeah, that's a copyright infringement. That's a copyright infringement. So yeah, Internet Archives lost that because they broke the law, like blatantly, not even close. So yeah, that does that. Okay, great. Next legal story. Ugh. Let's see. I am definitely not having my best day today. Ugh. All right. Don't care. Whatever. Tesla has been ordered to pay $3.2 million in a U.S. racial bias lawsuit. The electronic vehicle manufacturer Tesla has been ordered to pay $3.2 million in a lawsuit that alleged the company allowed for racial harassment to go unchecked at its flagship assembly plant in the United States. On Monday, a federal jury in San Francisco awarded $175,000 for emotional distress and $3 million in punitive damages, which I imagine that amount will be reduced dramatically on appeal because that ratio sounds illegal, but that'll be a fight, so fine. But that's what it is for the moment. Diaz has alleged that Tesla failed to respond when he reported enduring consistent harassment in his role as Lyft operator. Harassment apparently include racial slurs, caricatures, and swastikas. The decision, however, is a significant decrease from what a jury initially awarded Diaz. Warren's largest penalties for employment. That jury ordered $7 million in damages and $130 million in punitive. The district judge later slashed the total to $15 million, saying it was the highest award supported by the evidence. He cited the Supreme Court precedent, which asserts punitive damages should not exceed 10 times. That would be the problem. That would be the problem. And it's the same problem here. It's exactly the same problem. 3 million is more than 10 times of 175,000. So it would have to be reduced again. So, yeah. Diaz opted for a new trial to reassess damages. His lawyer asked the jury to award $160 million in damages. California requires employers to take reasonable steps. Mr. Diaz's outlook on the world has been permanently changed. Lawyers for Tesla, meanwhile, characterize Diaz as confrontational. They're just throwing on a number like this is some kind of game show. The legal team pushed for mistrial after Tesla's lawyers questioned witness over racial and sexual remarks. They could still order a new trial or appeal for the judge to reconsider the decision, which they absolutely will get because the amount is too high. And that is what's happening with respect to Tesla. Exciting. I love you, chat. I love you, chat. You give me the power to keep going. Some days aren't easy. Many days aren't easy. All right. All right. Let's finish this thing up. For our last story today, a story that's a couple days old, but I hadn't had a chance to cover it until now, so why not? The Maryland court has reinstated Adnan Syed's murder conviction. The appeal court of Maryland ruled the lower court had violated the right of the victim's brother to be notified and attend the hearing. So Adnan Syed had been convicted of murder. He had been the basis of the podcast Serial Season 1, which was the most downloaded podcast of all time. Raised some serious questions about his liability and guilt. His murder conviction had been set aside by the district court. The appeal court of Maryland ruled not so much and reinstated it, but it's a Pyrrhic victory for the victims. The Maryland's appeal court reinstated the murder conviction of Adnan Syed, who had freed after spending 23 years fighting charges that he had killed his former girlfriend. The appeal court of Maryland ruled the trial court had violated the rights of young Lee, the brother of the victim, to be notified. In a 2-1 decision, the appeal court or the trial court to hold a new hearing because of this problem. But the court will hold a new hearing and just come to the exact same conclusion. So it's a complete nothing burger, really. So I don't think there's much really to say about this, to be honest. Mr. Lee had argued the trial court had only given 30 minutes notice to rate home, gather his thoughts without input, and speak contemporaneously with no information. He asked the court to postpone the hearing so he could attend in person, but the judge denied the request. After Mr. Lee spoke, the judge vacated the conviction. He'd been serving a life sentence. The appeal court found that the judge had denied Mr. Lee's request to postpone the hearing, despite there being no showing it was necessary. Maryland law provides victims' relatives with a right to prior notice and right to attend. But as I say, it's kind of meaningless in the end. Because, okay, the judge messed up the procedural thing and he shouldn't have done that, but it doesn't matter. Because the judge will rehold the hearing, give the notice, and do exactly the same thing. I mean, so it's kind of pointless. So the conviction is technically reinstated for the moment, but very technically because it won't be reinstated for long. So that's what there is to say about Adnan Syed's case. There's nothing here. So that is the end of the stream. Let me see if there's any super chats that came in. I think there might have been. I know there were some gift memberships. Alan Parker gave a lot of gift memberships. Thank you. What day is it today? No super chats today. Just gift memberships, which is also fine. Yeah. So, all that good stuff. The TikTok thing, oh Lord, I don't have time for that. That's too much of a deep dive. But maybe I'll put it on the agenda for tomorrow. See if I can find a story about it, talk about it when I'm a little bit better off. So I'll try to put that on the agenda for tomorrow. It's a fair question, though. I'll put it on for tomorrow. All right. I'm going to sign off for now. If you've enjoyed this stream, please remember to give it a like. It really helps with the engagement. I really appreciate all the people who do the like thing and make sure to help spread the word of the channel. 252 of you here as we're getting this thing underway on a day when I'm not at my best. So, hey, I'll take that as a win. I think that's pretty good. We're just doing this thing. I'm not at my best, and the format's still a little bit in place. So, hey, it's all good. Please feel free to leave your feedback on the format, what you do like, what you don't like, where you would like more commentary, not commentary, stuff like that. And I'll try to read all your collective feedback and consider it as I'm considering things on my own. Also, we still need a swoop of some kind that would be appropriate for the channel. Some sort of Western themed swoop so we can swoop between stories. So if you'd like to design said swoop, you can contact me. So this has been fun. So I hope you enjoyed it. I've been Uncivil Law. Until later, yeah, 75 gift memberships today is not bad at all, man. That's nice. And thank you, Alan, so much for the gift memberships. And thanks for everyone else for being a member of the channel. It really does help and things like that. It's really appreciated. So all you guys kick ass. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.